Hello, everyone. Welcome back to another episode of Stuart's Soundbites. We're on episode 24, and this week we have something a little bit different and a real treat for you. We've got Max Archer and Kieran Mercer from Stuart's is also here, and they're going to be talking. And I'm not going to give away what the topic is because Kieran's going to introduce it properly and do a much better job than me. But as usual, we can take questions during the session. So if anybody has any questions, at the end of this, a slide will appear and there'll be email addresses on it. And if you want to follow up with any questions, then please feel free to use those emails. And I'm not going to say any more because I don't want to take up any time. So I'll pass over to you, Kieran.
Okay, thanks very much, Emma. So yes, as stated, I'm Kieran Mercer, and I'm a part of the aviation practice here at Stuart's. I've been joined by Max Archer. Max is a barrister at 12 KBW, and his practice areas include international and travel, and notably aviation claims, specifically those involving fatal accidents often, and those occurring under the Montreal Convention. Hi there, Max.
Hi, Kieran. How are you doing?
Very well, thanks. How are you?
Grand, thank you very much.
Excellent. So today we're looking at drones and specifically their regulation and the prospective personal injury litigation issues which might emerge. I think it's inevitable that we're going to see a huge increase in the coming years in the number of drones in our skies. A lot of this is being driven commercially. We've seen, obviously, quite famously, Amazon is looking to drones to perform a lot of its deliveries of our goods. And we're even seeing drones starting to replace fireworks in some event displays. So if we start with the liability regime, and specifically to begin with the strict liability provisions of Section 76 of the Civil Aviation Act, Max, what kind of issues do you foresee in pursuing a drone owner after an accident has occurred?
Well, the Civil Aviation Act provision that you're talking about, Section 76, is a strict liability provision, which is a very powerful tool in the hands of potentially injured claimants. It's a provision that attaches to air-to-ground collisions. So it's if an aircraft comes out of the sky and hits something on the ground, strict liability attaching to the owner of that aircraft, and it seems unquestionable that that could encompass drones. But the liability itself isn't really necessarily the issue here, because, as you'll appreciate, you have two further issues. The first is identification of the tortfeasor. Now, I'm sure you remember, I think it was in 2019 now, there was the Great Gatwick drone mystery, where a drone was running around the houses in Gatwick, caused loads and loads of flights to be delayed and cancelled, etc. And we still haven't found the police still haven't found the perpetrator. There's talk that there was no drone, that it was a mistake, but the police have come on the public record and said very firmly, yes, there was. We just haven't found the perpetrators. And you can imagine that being an issue for injured claimants as well, actually tracking down the person who's operating the drone at the relevant time. But I think a further issue is this, that even if you do manage to identify the person who was operating the drone at the relevant time, they may not be worth suing, because it may be, if it's not a commercial entity, they may be just a member of the public who's operating a leisure drone, and some of these drones are rather large. There's no mandatory insurance for drones under 20 kilograms.
Right.
Now, if you cast around your house and look for items that might weigh 20 kilograms, 20 kilograms weighs quite a lot.
Sure.
Large drone do a lot of damage, and there's no mandatory insurance. So you might have a drone causing, and clearly if something that weighs 20 kilograms comes into contact with a human being, it could cause a fatal injury, let alone a sort of head injury, catastrophic injury of all descriptions. So the fact that there's no mandatory insurance is potentially a huge problem. It might be the case that you can pursue a claimant, a defendant, owner of a drone, under their home insurance policy. It might be that, as I say, it's a commercial operator, and you might be able to use their public liability policy. But those are the two big problems that claimants face in an environment of ever-increasing proliferation of drones.
So largely you've sketched out there what would happen if an individual operating a drone caused the injury. But how would the situation be different if the drone hit an aircraft, for example?
Well, I'm glad you asked, because that situation is the nightmare situation that everyone's afraid of, and you'll have seen on the news, and indeed in the accident investigation bureau's reports into near misses. There have been loads and loads of near misses in the last 5 years, so they seem to go up every year. So the likelihood of there being a collision between an aircraft and a drone is extremely high, in my view, sadly, and that could have tragic consequences, because if we're talking about even a collision that could, let's say it happens over Heathrow or Luton or something like that, we're talking about areas that are extremely populous. So notwithstanding the loss of life potential on the plane itself, but you've got the surrounding environs to think about as well. So what would happen? What's the liability situation? Well, for the injured claimants on board of the aircraft, happily, I suppose the Montreal Convention would respond, wouldn't it? Because you have an accident and there's strict liability attaching to the carrier in those circumstances. But it's likely to be the case that the carrier could rely on the reverse burden of proof that kicks in after the value of the claim hits 100,000 special drawing rights. Special drawing rights being a kind of weird aviation currency that equates to about £90,000 or so, I think, at the moment on current measures. So strict liability, the regime imposes strict liability for the first 100,000 special drawing rights, and then after that there's a reverse burden of proof, and the defendant can point to the accident being the fault solely of a third party. So, and in the situation that you described, Kieran, it's quite likely that that's the case, isn't it? Because you have, if a drone flies into collision with a let's say a 737 or something like that, it's unlikely that you could say, well, it was the carrier's fault. That's likely to have been the fault of the person who was operating the drone, because there are regulations that indicate that a drone shouldn't be flown around airports, self-evidently, and that there's good reason for that. So that could be a bit of a difficult situation. So you might have to find other targets to sue. I suppose potentially you could say, well, the airport or air traffic control should have detected the drone. Might be a relevant question to ask. And then there's the question of other targets, which I think we'll come on to speak about in a second. As the owner of the aircraft, be it very large or very small, be it a commercial flight or a private leisure flight that's come into collision with a drone that causes damage, property damage, injury or death, you're in the same position that we talked about earlier. Finding an insured defendant to sue might be the issue, and that might be the issue for any contribution claims for carriers as well.
So you've touched on potential targets there for liability, and potentially would a regulator be brought into such an action? Can you envisage the CAA, for example, potentially?
Yeah, potentially, although that's not easy. So I think there's two potential routes to liability. The first is a Consumer Protection Act action against the manufacturer of a drone. Now, lots of drone accidents, and I'm not just talking about air-to-air collisions here, but ground-to-air as well. Lots of drone accidents involve things like motors failing, dodgy auto navigation, drone rather than human errors. Now, if it's possible to pin that failure on a manufacturing fault, then it might be possible to sue under the Consumer Protection Act 1987 on the basis that the drone is defective within the meaning of that statute. And I say within the meaning of that statute because defective, in inverted commas, is a notoriously difficult concept to grapple with. And I don't know if you followed, Kieran, the metal on metal hips litigation that's progressed through the courts in that case G and Dupuy International. Strict liability is meant to be the effect of the Consumer Protection Act, but it seems to be anything but. It's a very, very difficult provision to grapple with, and it's by no means certain that every manufacturing fault would satisfy the requirements of that act. And there's also the potential for a manufacturer to be able to rely upon what's called the state-of-the-art defence. That is that it effectively wasn't discoverable due to the state of technology. And that might be the case if, for example, a self-learning algorithm goes out of control and causes an accident, which is definitely a possibility, and given the complexity of the technology involved with some of these drones. Yeah. Probably the case in a failed motor, but nonetheless something to think about. I'm not saying it's a doomed course of action, far from it, and it may be the only port of call for some claimants and indeed defendants seeking contribution, but it's not going to be easy.
Right.
And the second, of course, is as you touched upon, it's the Civil Aviation Authority, and there I suppose the case is, well, it's a negligent failure to regulate the use of drones. Now, on authority, we know that the CAA owe a duty of care to members of the public to carry out their functions with reasonable care. And there's a case from the mid-1990s called Perez and Collins. Right. But we don't have a clear handle, because there haven't been any authorities on this question since then, on the scope of that duty of care, on how far it extends. Now, Perez is quite a distinctive case. It involves the negligent inspection of a kit plane, but it's still good law, and it should be noted as well that case, the defendant was an individual carrying out the functions of the CAA. So it still was the CAA in the dock, as it were, but it's quite a distinctive case. So that case is quite different from saying, well, you ought to have regulated more stringently to prevent this accident. It's not impossible. There's a difficult line of authorities on the question of regulatory liability, and you'll have seen that, Kieran, I'm sure, in the GN case that was in the Supreme Court on very, very different, nothing to do with aviation at all, but on failure to remove cases last year. So, or the year before that, rather. The lockdown is bleeding all the years into one for me, I'm afraid.
You're not alone, yeah.
Yeah. 2019, 2020, all just or something. So regulatory liability is on the move, and so it's something that I think we're all looking at with interest. As is liability for the creation of a dangerous situation. You might have seen the recent Begum case about shipbreaking, about liability for creation of a dangerous situation. You might be able to argue that the Civil Aviation Authority licensed a dangerous situation, so they might be liable. But those are difficult arguments to make.
Right, understood. And if we have a look at some very recent legislative change, the Air Navigation Order of 2020 came in at the end of that year, and it's removed the distinction between non-commercial and commercial drone operations. And the decision was taken to move to a risk-based regime, regardless of the purpose for which the drones are being put to use. So how do you foresee that affecting, firstly, the number of drone operators, and then also the number of flights that we might see in our skies?
Well, Kieran, I think the answer is that I don't know. And and that's because it's not just because this regulation is new, but I suppose in theory, a tighter regulatory net should deter people from taking risks with their drones. But I think, and I'm sure you agree, that the numbers of drones in the sky are going to increase, notwithstanding this regulation, because the technology is just going down in cost, and the applications are getting greater and greater. And I mean, you spoke about this at the very beginning when we started talking. I mean, it's even being used in fireworks. I didn't know that. It's just the proliferation of this technology is just too tempting. I'm not saying I'm anti the use of drones. I hope that hasn't been the thread coming through our conversation, Kieran, because I think it's a fantastic piece of technology. But all we're doing here, I suppose, is highlighting the risks that are associated with the use of that technology. I don't think that the air navigation order is likely to have a huge impact on the risk of injury. There's a provision in there that says that you mustn't fly a drone in such a way that endangers life and limb. Right. As we've discussed, that's probably likely to be a slightly redundant part of the regulations because of the potency of causes of actions that are available that predate this regulation. The broader point here, I suppose, is that the regulations want to maintain a balance between allowing this technology to be used in these new commercial applications in particular, and protecting the members of the public. And we're getting there. We are getting there. The registration requirements are, in my view, very important. I think what's the missing piece of the puzzle here is insurance requirements. I think that should be set at a lower weight limit. I really do, because I just think 20 kilograms is very big. And I appreciate that most members of the public who have bought drones from Maplin are buying pretty small drones. That the risk is probably quite low arising out of those drones, although you can foresee there might be some injuries that arise out of their use. But people are allowed to fly quite big ones, and that's where the risk really lies.
No, absolutely. Well, I think that's probably about all we have time for today, Max. I'd just like to say, obviously, thank you very much for joining us and providing your insight on some of these issues, which are likely to be pertinent in what seems to be a very interesting emergent area of both injury litigation and aviation in general.
It's my pleasure, Kieran. Thank you very much for having me.
Yeah, thank you. Just to echo Kieran's sentiments, thank you so much, Max. And I'm looking forward to my first Amazon delivery by drone with equal measures of excitement and caution. But it's fascinating. It's a fascinating area, and really, really great to have you on today. So thank you very much.
Thank you.
Take care. Bye-bye.
Thanks, Max.